Alto office, sorry, in our Palo Alto office, and I practice mergers and acquisitions, and I do a little bit of corporate work. Most of the companies I represent are technology companies, both large technology companies that people would know, and then smaller startups. Brandon, if you want to introduce yourself.
Yeah, sure thing. Thanks. So Brandon Middleton Pratt. I too am an attorney at Wilson Sonsini, based in the Austin office. And my practice, similar to Broderick's, includes what we call M&A, or mergers and acquisitions, which is helping people buy and sell companies. And it also includes working with tech companies, the kind that Broderick sells or buys, and working with them at all stages of their life cycles. So from startups to just before they go public and get traded on public exchanges, or otherwise get bought or sold. And in addition to that, I also work with founders and entrepreneurs in all things related to startups, helping them think through strategic and tactical questions, some of which we'll talk about during our discussion today. A few other kind of points that I'd like to relay at the outset before we kind of jump in is that we'll be talking to you today and using to guide that discussion a slide deck we put together called Legal Landmines Every Startup Should Avoid. This presentation leans a little bit towards tech companies, but there's plenty that we'll cover that is more universal in nature, and that will apply to all sorts of companies, whether tech or sort of old school retail, brick and mortar, providing services through a physical location, etc. Some of this stuff is going to be very universal. As we walk through this, we encourage you to ask questions, either through the chat is how you'll do it here. I don't see any other sort of individuals in the feeds here, so I guess through the chat. So please do. If while we're going through this you have questions, please raise them. It makes it much more interesting for us as we kind of walk through this. And I think with that we can sort of jump in. Well, I guess one more thing. This presentation will also be pretty broad, and that will touch on a bunch of different topics and areas. But again, we hope that they're going to be areas that are relevant to you and what you're thinking about and dealing with, and or will be or have, or so again, it'll be sort of broad in scope, but hopefully relevant to you. So with that, I think we can jump in. Broderick, anything else before we go?
No, I think we should use them the most of the time we can, so let's get started.
Absolutely, yeah. All right, so I will pull up and share, if I can figure it out, that I can, the slide deck. Hopefully that's coming across. Project, can you give me a thumbs up? Or you're seeing this? Okay, great. Let's get it. Even better, I think. All right. So, as I mentioned, legal landmines every startup should avoid. So, the first is failing to form a business entity. And forming a business entity is important for a few different reasons. Foremost of which is that if you don't form an entity and you operate your business as yourself, then you're not affording yourself of limited liability, which means that you know, you are liable for any issues that arise or obligations that land on the business. And what does that mean, right? It means that your assets are on the hook if you get crosswise with a counterparty to a contract. So if you have a supplier and you sign a supplying agreement with them or a supply agreement with them, and for whatever reason, things fall apart and they get upset and they sue you, well, if you haven't formed an entity and that entity, and you haven't made that entity the counterparty, the party to the agreement, but instead it's you, well, all your assets are potentially on the line, right? So, if you have a house or savings accounts, right? All those things are on the hook if you don't avail yourself of limited liability, right? So how do you do that? Well, it's forming particular types of entities. So an LLC, which is a limited liability company, or a corporation, or in certain circumstances, limited partnerships. All right, so you want to form an entity because you want to make sure that not your personal assets are on the line, but instead the entity's assets are on the line. And usually the entity's assets are whatever the investors have put in it investment-wise, or any assets that the company's built up over time as it operates, right? But that's different and apart from your personal assets. And as I mentioned before, this deck skews a little bit towards tech companies, and in particular tech companies that might be looking to raise capital from professional institutional investors in the venture capital space. And if that's the case for you or for a company you intend to work on or build, then you'll want to incorporate as a C Corp in the jurisdiction of Delaware. And it's for several reasons that venture capital investors prefer, and in some cases have to invest in Delaware C Corps. A few of them are Delaware has really sophisticated, well-reasoned, well thought out, long storied, what we call case law. And so that gives folks real comfort in being able to predict and understand how a Delaware court would interpret language. That's probably the sort of the main point. People know what the words, how the words will be interpreted. And as I mentioned before, because of that, if you want to or intend to in future raise venture capital, you want to form your entity as a Delaware C Corp. Okay.
So I think just to piggyback on what Brandon said too, it doesn't even have to be venture capital. If you're seeking investment from anyone, you want to have your kind of your business and your personal resources separate. This particular topic of paying too little attention to corporate formalities relates to how you actually maintain and limit your liability. So if you start a business and you have a separate entity, but you treat the business as your personal piggy bank, or you continue to operate as if it's not a standalone business, there are legal arguments that people can make that would quote unquote pierce the corporate veil. And basically your assets that are commingled could all be available for someone. So for example, if you breach a contract and you are operating kind of in your personal capacity as well as the corporation that you had set up, it's potentially an issue where you could be liable both in a personal capacity and the corporation itself. So the main point here is to make sure that if you are going to form a corporation or a limited liability company or a partnership, you actually follow the formalities, which is to enter into contracts with that entity to make sure that the money that's paid on those contracts or earned on those contracts are in a bank account that's specific to that entity, and that you're not commingling funds or mixing and matching, just to make sure that the separateness is there throughout. So it's how you present yourself in terms of your marketing. It's also how you run the business in the background, so accounting records as well, bank accounts. It's all of those things, and making sure that the corporation is a standalone organization and it's separate from you, the business owner, the individual. So I think that's the general point there. I think we should stop, and if there are questions, let us know. Happy to cover anything if it wasn't clear, or to move in a slightly different direction to the extent people have questions.
Yeah, there was a question in the Q&A. It says, how can we have our sole proprietorship business history become part of our LLC or S Corp?
Got it. So I don't, it wouldn't necessarily be the case that you would lose kind of the business history of your sole proprietorship, but it would just be the case that when you form the entity, that would be the beginning of the LLC. But the relationships that you had, you would just transfer over to the LLC. So if things were in your name, you would just transfer the contracts to your LLC. And right, that would relieve you, the individual, of liability, hopefully. And then it would just all sit with the LLC. Brendan, did you have a different view, or what do you think about that?
Yeah, no, I think that's right. And right, so there's sort of the official, right? And officially, whenever you would form up your entity, and maybe it sounds like an LLC might make sense for you, that would be, as Roderick was saying, the start of the life of that LLC from an official standpoint. But from the perspective of, let's call it the market, or I don't know what business you're in, your customers or your suppliers, whomever, it wouldn't have to be obvious to them, except to the extent you're going to be renewing agreements, or some have a really long life to them. Maybe you want to get them transferred. But as you renew agreements, as Roderick was saying, you would sort of, relay to that counterparty, hey, we've actually changed sort of structure or whatever, but it's the same people, it's the same business, but now you're going to be dealing with, Acme Company LLC instead of whatever it was before.
And then it looks like, Brandon, there's another question in the chat about how do you go about forming the LLC or the corporation? Should you hire a lawyer? Should you use NOLO, or what would be the best approach? I would say all of the different options may be appropriate depending on your level of sophistication. The benefit of talking to an attorney is that they can modify the forms that you're going to get on NOLO or an online website so that it actually suits your purpose and your needs. If you go online and you just kind of sign up for something, it might not be appropriate for what you're trying to do. The other part of it too is you probably need a little bit of guidance in terms of what the next steps are once you form the entity. So some of the online websites won't really provide the guidance that you need. I would say, like, if you can, there's tons of pro bono organizations that are available and that would help you form the entity. And then separately, right, if you want to go to an attorney, it shouldn't be very expensive because it's a limited kind of engagement. So it shouldn't be too expensive, and you shouldn't pay a lot for this. You can do it on your own with research, but I think sometimes you can get much better advice that's specific to your business and your goals if you talk to an attorney. And I'm probably biased since I'm an attorney, but we'll put that out there. Brendan, did you have anything else to add?
No, I agree with that. Again, it really does sort of depend on what your needs are and what you anticipate next steps being. You know, it may be the case that using a NOLO or, you know, some other service provider to kind of generate, you know, fairly generic documents may be right for you. It's hard to know that until, you know, you've had, at least for me, until I've had a chance to sit down and visit with you and kind of hear about what your business needs are and in particular, kind of where you anticipate, you know, going, what the future, what you envision for the business's future. But generally speaking, all things being equal, and if it's affordable, then yeah, you'll want to get, you know, you'll want to get some legal guidance. You want to get some expertise to make sure that it's tailor fit to your situation.
All right, and then Brendan, I guess we'll do questions because it seems like that's where we are. The next question is the new LLC should have a new EIN also, correct? Yeah, if you're going to have employees, you want to get an EIN after you form the entity. So it makes sense to just do that and start that process once you form the LLC.
And you'll want to do that for other reasons. I mean, you know, oftentimes when you want to open up a bank account or something like that, you know, you may be asked to produce an EIN. So there are practical reasons in addition to, you know, HR related or employee related reasons.
Yep. So for those who don't know what an EIN is, an EIN is like the social security number of a company. So it's the employer identification number, and it's what the IRS uses and issues to entities as opposed to individuals. So the point being, yes, once you start your business and you form either an LLC or a corporation or a partnership, you should get an EIN. And let's see, we have another question here. Sorry, I just need to make this larger so I can see it. Besides being in the restaurant business for more than 25 years, my husband and I also toured and performed professionally and created our own record label and recorded 29 album CDs, 2 of which were Lion Grammy nominated. My husband was the composer of many instrumentals on these albums, and he and I wrote lyrics together. We have a US copyright registration for all these albums. In the early days, CD Baby was a grassroots company, and we let them put our music on the newly formed iTunes and a very few other places. And they paid us royalties. The company has been sold twice to big corporate companies. These corporations have put our music on Spotify, Amazon Music, YouTube without our permission. They send us small amounts in royalties, and some of our songs on Spotify have more than 500,000 hits. How can we remove our music from YouTube? What do you recommend? So this one is probably outside of the scope of this particular workshop, but what I would say is this relates to IP and who owns the rights to the particular music. And so what would generally, you have to speak to an expert, and I'm not providing legal advice about this in particular, but you'd need to kind of figure out if you're the owner of the IP, and if you are, then you would just you know, contact the different music providers and let them know that they need to remove it because it's not owned by whoever is saying they own it. It's a little bit of a process, but I mean, as a starting point, you'd need to prove that you own the actual rights to the music. Brandon, I don't know if you want to jump in on this one.
I don't have anything to add other than you'll want to speak to an attorney who specializes in, you know, music related IP stuff, right? Because it's a field that's got its own nuance, and you want a specialist who deals with that. If our contact information hasn't been made available to you, we'll do that before we end, or we'll ask Anna to. We happen to have such a specialist in our firm, right? So might be happy to pass along contact information if you wanted to visit with this, with an expert, a specialist in that field. But yeah, I don't have much to add to the narrative beyond what Broderick said.
And I think there might be one more question we can address. So let me see. Oh no, that's it. That was the last question. So, Brandon, we want to talk about equity next.
Yeah, I can do that. I just want to say one thing on the piercing the corporate veil. Oftentimes, when there's that commingling and not sort of operating the business as a standalone, then you can find yourself in this gray area of like fraud basically. And there's like some really interesting stuff coming out of what I'm sure is going to continue to spin out more news with the bankruptcy of a company called FTX. And FTX was this crypto trading platform. And it looks like, and we'll kind of see how it all plays out, but it's widely reported that the founder of that platform basically was able to go in and transfer and move out assets from the company to himself and to other companies that he owned or was affiliated with. And so I think he's currently in custody in New York, and there will be a trial to play out, but that's the sort of thing. Obviously, that's, the accusation there is like rampant, pure fraud. But if you're using a company as like a personal bank account, you can muddy the waters pretty quickly. And if you get crosswise again with a counterparty or get sued, you don't want them to be able to point to that, to be able to go beyond the company's assets and to be able to go around the limited liability that we've worked so hard to make sure you have, right? Okay, so see if we can move to the next slide. All right. So continuing on, landmines to avoid, right? So failing to appropriately address equity. And so what do we mean by that? Well, first off, anytime an entity, an LLC, a corporation, and by the way, for the most part, when I talk about a company or a corporation, I'm talking about an LLC or a corporation. But whenever sort of a company grants or issues equity, it formally has to be approved by the governance board of that entity. So for a corporation, we're talking about a board of directors, and for an LLC, it can be a governing member, it can be a board of managers, but whatever that is for that entity, right? It needs to, the company needs to be given the authority by that board or that governing member. Something that we come across more frequently than we'd like is not formalizing equity issuances or grants. And so we hear all the time that a founder or an owner of a company made a promise that somebody was going to get some equity stake, either because they were anticipating a sale of the business and, oh, we'll give you 1% of the business, or just generally speaking to sort of incentivize employees or supplement cash salary. And we can't sort of advise strongly enough against that, right? To the extent you're going to be doling out equity, again, it needs to follow the formal process and it needs to be documented. And if for no other reason, to protect yourself in future from someone, saying that they were supposed to get more than you'd sort of orally agreed, right? You want that to be documented so everybody's very clear on what the expectations are and exactly what the cap table looks like. And so cap table, cap is short for capitalization table. And that is basically just an ownership table of the company. And so it shows the percentages or the number of shares or units that are held by an owner. So, if there's one owner, then 100% is held by that owner. But as soon as there's more than one owner, this becomes really, really sort of important. And so you want to make sure that you've got somewhere reflected the ownership of the company, right? Not that you're going to be publicizing it or sharing it broadly with a bunch of people, but so that all of the relevant folks who need to see it are looking at the same thing. Again, it's to make sure that people's expectations and their understandings are aligned and everybody's seeing it the same way. Okay, so for certain types of startups, in particular tech companies, there's this sort of notion of founder's stock. And again, this is one of those areas where this presentation skews a little bit towards the tech venture capital ecosystem, but it's not limited to that. So we'll want to follow along here. But this basically gets back to the point of making sure that we are being appropriately formal when it comes to issuing stock, making sure that we have a record where we're keeping that and updating it to the extent we issue more stock, the cap table. And with founders in particular, we want to make sure that we're observing those same formalities. This is especially important where you've got more than one founder. It's important for one, but it's really, really important when you've got more than one. And when you have when you have more than one, there's this concept of related to equity called vesting. And that basically means that, yeah, we've issued it to you, but it's not fully yours until some either time periods have gone by, or there can be vesting based on something other than time. But usually we're talking about time when it comes to founders and new companies. And so that basically means that I think of it as there's a string on the shares that are granted to founders, and those strings fall off as time goes on. But if you somehow leave the company or cease to provide services to the company before those time periods lapse, then the company can pull the string and pull the equity back away from you. So vesting is really about sort of perfecting your ownership such that it can't be repurchased or bought back from you by the company. And so when we talk about founder stock, it's usually issued early on in the life of the business. And so it's almost basically no price to it. So it's got no cost. And it's usually, we advise it be subject to vesting, because if you go and get venture capital, then they're likely going to put a vesting schedule on it if there's not already one, if there's not already an existing vesting schedule. And if you've gone too far into your vesting schedule, they might want you to revest. Other important things to keep in mind for company owners and founders, to the extent you want to issue equity to employees in the form of options, and options are a call right to be able to buy stock for a predetermined price called a strike price or an exercise price. And it's one of the main ways in which new companies, new corporations incentivize employees when that corporation doesn't have a bunch of cash. If you're going to do that, you need to get what's referred to as a 409A valuation. And a 409A valuation is basically in the tax code, it says that if you grant options at fair market value and you get this particular type of valuation to demonstrate that, then you can get the beneficial tax treatment that you're looking for options. The point here is all options need to be granted at the fair market value of the common stock underlying that option. Otherwise, the company and the optionee risk some fairly punitive adverse tax consequences. Okay. Let's go to the next.
And before I start, if anyone has any questions about equity, we're happy to answer them. But failing to raise enough capital. So once you formed your business, and now you're looking for people to contribute additional money to your business, or you're going to manage it yourself, there are certain things that you need to take into account. So the first one being, if you're going to fundraise and go out and seek capital from outside investors, you have to make sure that you do it in compliance with securities laws. The larger the group is, the more concerned you should be about whether you're complying with securities laws. On that point, I think, Ray, you probably want to consult an attorney, so we won't cover it here, but it's just something to think about. The next point being, don't fear dilution too much. And the point here is, as you're going out and you're giving or selling parts of your equity or a portion of your business to others to bring in capital or to bring in expertise. If you've watched Shark Tank, you've seen that, right? Where they have the kind of the back and forth about someone only wanting to grant 10% equity instead of 20. I think, right, you don't want to have a ton of dilution where you're giving away your business, but on the margins, it might make sense to give away a portion of the business to achieve some other strategic goals. And you do have to do the cost benefit analysis, but you shouldn't really focus as much on 1% and 2% and more about what value it's adding to the long-term benefit of the entity. If you are going to go out and fundraise from the public, and it is a very time-intensive activity. If you're kind of a sole proprietor, even if you're just going out and asking friends to help support your business, right? We've all kind of done that and know that that's hard work just as much as like if you're a founder of some new startup raising money from big funds. It just takes time to explain to people what your vision is, what your dream is, and to get them to buy into it, and then to give you their money to go, build out your dream or potentially their dream. And then the other part of this is, once you do form an entity and you brought in a bunch of capital, you got people who are willing to invest in you, make sure you're spending the money wisely on the things that kind of are moving the business in the right direction, and that you're not just spending because you have cash on hand and because you can. You want to be thoughtful about your spending. There's no kind of right under the law, right? You have to act with proper business judgment. So it's not as if you lose a bunch of money, it's a problem, but you don't want to kind of use the money of your new company that has limited liability in ways where your potential investors could sue you. So just something to think about as you're going through the process of actually running the business. Brandon, I don't know if you had anything you wanted to add to that.
Yeah, no, I think that's right. And the bottom of the slide says, things tend to cost twice as much and take twice as long as expected. And that's just a good rule of thumb. It's not always true, but it's a good rule of thumb to sort of organize around. And I can say it also applies to taking on renovation projects. My wife and I are in the final throes of trying to renovate an old home, and it's certainly taken more than twice as long and perhaps cost more than it should as well. So not limited to advice to founders and entrepreneurs. And one quick gloss on the complying with securities laws. As Broderick said, not going to get too deep into it, but basically, the government basically sort of takes the view that it needs to protect everyday regular investors from unscrupulous people and from getting into investments they don't fully appreciate or don't have enough information to fully understand. And so the upshot of that is, every offer or sale of a security, which equity in your business, shares, units, membership percentage, et cetera, is a security for purposes of this conversation, is one of three things. It either gets registered with the SEC, has an exemption from the requirement to register with the SEC, or it's illegal, right? So that's just a little bit of high level initiation for those who haven't yet come across it, securities laws, and you certainly want to be getting guidance from counsel who has facility with securities laws and their requirements when you sort of move beyond the founding founders, friends and family, capital raises.
So Brandon, before we jump, we have a question in the chat. Is the best way to transfer business assets to personal use a paycheck to the owner? So I think what this question is getting at is, once you form the entity, how do you effectively compensate yourself so that you actually can make a living and kind of, benefit from the kind of the work of the corporation? And so on this one, if you start a corporation, and you're the owner, you can also be an employee of the corporation, and there's sometimes benefits to structuring it that way. If you start an LLC, it might make sense for you to be an employee, it might not. There's a number of different considerations that you want to take into with kind of the taxes that are associated with becoming an employee, and whether it makes sense to not pay yourself and just take the profits out of the business. So I think it depends on if you're forming an LLC or a corporation, and then separately kind of what you're trying to achieve in terms of how you're paid back, if it's, for tax benefits, or just because you need kind of the cash, but you don't actually need a significant amount. Brandon, what do you think on this one?
Yeah, I think that's right. And so I imagine this question is sort of coming out of the observing corporate formalities, not wanting to, find yourself in, piercing the corporate veil territory.
Yep.
And so I think what Broderick said is right. And whether it's an LLC or a corporation, again, going back to just sort of observing the formalities. And so in addition to, visiting with, you'll definitely want to visit with, an accountant, a business accountant, a personal accountant, to make sure you're understanding all the tax consequences of your structuring. But, corporations can dividend out, right? So long as, that wouldn't sort of render the corporation insolvent, right? So you'll want to follow whatever your documents say, follow formalities, the board approves it, that sort of a thing. Likewise, on the LLC side, you'll want to just follow, to the extent you have what's called an LLC agreement or an operating agreement, what it says about making distributions. They are allowed, right? It's just that if there's a process that your documents specify, you'll just want to follow those. And to the point about, again, trying to be as efficient, if it's a goal of yours to be as efficient as possible with respect to taxes, then you'll definitely want to consult with an accountant. Sometimes, going back to the point Broderick was making about, if you're the owner, you don't worry about it as much on the corporation side, although it's still at play, but you've got a whole regime of self-employment tax that sits on top of the ordinary income tax structures. And so you'll want to visit with an accountant to make sure that you're understanding how that all plays out together. Sometimes it's, you'll be an LLC and you want to make an S Corp election because that allows you to minimize the amount of self-employment tax. And so all those things are conversations that you want to have with an accountant or tax advisor.
But I think the larger point is just that you can get money out of the business, and you don't have to be an employee to do that either. You can pay yourself from the profits of the business, and not be an employee per se. But as Brandon noted, it's really depending on your personal circumstances, going to be a tax-driven kind of analysis.
Yeah, and just to sort of help to hopefully create a distinction between that and what we talked about before about commingling, right? So you're running your business, the business has some profits from which you can pay yourself, so you cut a check to yourself from the business, and now that, so you cut a check from the business account into your personal account, right? And you use the money in your personal account to do whatever it is you do with your money. That's different from you using the business's account to treat yourself to a spree at Saks, right? Or using the business account to pay your personal credit card bill, right? So that step of the corporate or business account, drafting a check to your personal account, right, is important here, and honoring the distinction between the business and your personal. Does that answer the question? Hopefully. Okay. Okay. All right. So, depending on your business, IP can be really, really critical to it, or, not so critical. But I think all of this is sort of worth spending some time to talk about, right? So, going back to starting up your business, or it's already going, this is less important for the sole proprietorship type business, even though we advise you to still formalize and be an entity where there's sort of one person. But where there's more than one founder, where you have employees, where you're using contractors, it's really important that anybody who comes into contact with on the company side, right? So founders, employees, contractors, advisors, and the like, that they sign what's called an IP assignment, because that IP assignment will say, if drafted properly, essentially, all of the IP that I work on, help build, whatever, and relation to, in connection with my service providing to the company, belongs to the company, right? It belongs to the company. It doesn't belong to that individual employee or consultant or advisor or founder. It belongs to the company. And that's important for current and prospective investors, right? Because oftentimes, again, depending on the business, the IP can be sort of the core value, right? And even for businesses where it's not the core value, you still want it to be really clear that the company owns the IP and not individuals. So, in order to do that, or as part of that, you want to develop and implement a comprehensive IP strategy. And what's that really mean, right? It's a plan for how you develop, grow, leverage, protect, and monetize the company's IP. And so, going back to one of the previous questions / comments, right? Copyrights are in there, right? And so the advice is, again, especially for something specialized, like, we're making music, we own the rights, we've been receiving royalties. You want to definitely make sure you're working with an attorney with appropriate expertise in that space, especially as you look to go up against the YouTubes of the world, to send them a letter to say, hey, we own this, right? And we don't want you to make it available on the platform. Okay, and then going back to sort of that comprehensive IP strategy, a part of that includes the use of confidentiality, or also referred non-disclosure agreements, right? And generally speaking, whenever your company is in position to potentially share confidential information, or what we call trade secret, right? The way you do something that's your secret sauce. You should always consider whether it makes sense or it's appropriate to have that party that you're going to be sharing that information with, sign up to an agreement that says, hey, we're going to keep this and treat it. We're going to keep it confidential. We're going to treat it confidentially. We're going to take certain measures to make sure that we live up to those obligations to treat it confidentially. I will say one sort of carve out to that is going back to sort of that venture capital lens. Venture capital investors, by and large, do not sort of sign confidentiality agreements or NDAs to have introductory or even second level, third level, conversations with you about your company if you're, hoping that they'll invest. It's market practice that's somehow came into play. But while this is true, you ought to consider having folks sign up to confidentiality agreements. As market practice, understand that most VCs won't sign them.
So I think though where this would come up to, even if you're not running a tech business, right? Even if you're opening a food service type business where you're selling your family's recipe for cookies or sauce, right? You want to have employees that are working with you sign non-disclosure agreements, confidentiality agreements, so that they don't, have the ability to go out and take your trade secret, your recipe, and go start their own business. So this is actually one of the areas where IP kind of suggests that it's very kind of grand and broad, but it's really about what your business does on a day-to-day basis and protecting that. Now, there's certain things, right, that you can't, like there's processes that you can't necessarily protect, but if there's something very specific or special about what you're doing, you do want to put agreements in place to make sure that someone can't take your idea and use it. And Brent is right that like big investors, you can't get to sign up to these agreements, but other folks you can. So if you're going around telling people your ideas and the business you plan to start, you might also want them to sign NDAs too, so someone doesn't take your idea and run with it, or take your hard-earned sweat equity and run with it, and you've done all the hard work and then they kind of use it to their benefit. So and there's tons of enforceable and usable NDAs on the internet. So this is one area where you probably can get away with using a form. I mean, obviously an attorney is going to be able to kind of make it most appropriate for you, but it's better to have the form in something rather than nothing. So this is the area where I think you should really focus on when you're building your business. The next slide, and we can, I know we're getting short on time, but the next slide focuses more on just kind of making sure that when you start your new business, you're doing some of the groundwork so that you're not infringing on someone else's IP, or, and this is simple enough as just don't pick a name that's already out there, right? Like, you don't want to do that. You don't want to get sued by some big company because you're using their name and they've told you, and they won't notice in the beginning. It'll be when you start to have a following and you actually want to keep the name that they'll come after you. So here you just want to do the search as early as you can. And again, for most of these, you can do a Google search to find if a name or some things are taken. For entity name, in most of the states, you can just type in, like California entity search, the Google link will pop up and you can search to make sure the name isn't used. The same thing if you're forming a Delaware corporation or in most states. So that one you should definitely do. And then on the domain names, normally if you try to form it or buy a domain name that's taken, like GoDaddy won't let you or whatever service you're providing, but you do want to do the search just to make sure that someone doesn't own the domain name that you're going to build your business around. And then
Right.
We have a little bit of time left, so Brenda, I'm going to let you do the key documents to start with. And if we have questions, we can answer them, but I think we should just think about the documents.
Yeah, I think that's right. I think that's right. Just one point on the not all names can be trademarked, the purely descriptive name. An example of that is, you can call your brand Apple if you sell, computers and smartphones, but you can't call it Apple if you sell apples, right? You're not going to be able to protect that to stop other people in the Apple game from doing that. Okay. All right. So key documents.
We have one question. Is it legal to ask a future employee to sign a non-disclosure before they become an employee?
So I'm not an employment and labor specialist, but ordinarily you would have them sign that sort of as they come on. And I'm trying to think as to why you would have them sign it before they would kind of come on.
Yeah, I think if you're having them sign it because you're going to tell them ideas and stuff and you want to make sure that they don't use it, that's fine. But then once they start as an employee, you probably would need an NDA that's more catered to the employment context. So you probably, unfortunately, would need two. So you need something to cover the discussions if they're not actually working for you. And then separately, once they become an actual employee, you probably want a slightly different NDA to cover more of the things that are specific to the business, whereas the one you would have if you're just having conversations with someone would just cover any information you give them. The employment one, because there's laws about kind of how you can restrict individuals and how they work for you, it needs to be catered a little bit. So I hope that answers the question that you should probably have them sign one before and then once they become an employee, and they should be specific to the two circumstances. Sorry, Brandon.
Yeah, no, that's a good point. Hopefully that sort of got at what the question was asking. So key docs, we talked about some of these before. So among founders, you want to get the IP assignment agreements, right? You want it to be clear that the company owns the IP. And the key corporate documents here are going to be, if it's a corporation, it's the governance docs plus some others. So if it's a corporation, it's a charter, bylaws, anything going back to what we said before, touching on equity, you want that to be, documented, right, formalized and reduced to writing. And so those are what we're getting at with these sort of, key documents among, founders and owners. And then we've talked a little bit about some of these others for
Brandon,
employees and contract.
Before we jump, so just because I know it can be confusing, for the corporation, a charter or a certificate of incorporation are the same thing. And that's the document that says this entity has 100 shares to issue, it's authorized. I'm picking a random number. And then that's what gives you kind of the power from the state to be a separate kind of organization. And then it lays out the basic ground rules of how the corporation is going to be run. And then the bylaws are more geared towards the specific members and the day-to-day management of the corporation. That is less driven by state law and more just about how the board managing the corporation wants to run the corporation. There's certain things that obviously need to be in the bylaws that you have to have, but the kind of the document from the state is the certificate of incorporation or the charter or the articles of incorporation. And then the kind of internal document that determines how meetings are handled, whether you can do certain things, that's the bylaws. And then for an LLC, it's an operating agreement. Sorry, Brendan.
No, that was good to define. So I think we're at time. there are 5 or 6 more slides that I think, like, all of the slides relay the information pretty clearly and easily, but and we'll sort of coordinate to make sure that the full slide deck is made available to you. And as mentioned before, we'll also coordinate to make sure that you get our contact information. If you have any other questions or follow-ups, please don't hesitate to reach out with those, and we'll try to respond to you with guidance and try to be as helpful to you as we can be. I want to say thank you for taking the time to visit with us today and listen to our presentation. Thank you so much for being so active with putting questions in the chat. That really livens the conversation, and so we appreciate that, and hopefully this was helpful to you. And as I mentioned before, we look forward to hopefully hearing from you. That's all I've got. Broderick, any parting words?
No, it was great speaking with everyone. Happy to answer questions. And as Brandon mentioned, we definitely are happy to help guide you in terms of next steps and provide resources if you can go the pro bono route, and we can do that as well, so that you have kind of the assistance that you're looking for. So great speaking with you today, and I'm happy to answer more questions, and we'll kind of make ourselves available as needed to answer questions.
Okay, thank you, Anna. We'll give it back to you.
Sure, you're on mute.
Muted.
Oh, yep. Thank you so much. Both of you, Broderick and Brandon, and Wilson Sonsini, for supporting our workshop and our work. We really appreciate it. It sounded like such an informative workshop, and I'm glad folks were able to answer to get questions answered. I'm going to go ahead and send a link to our legal clinic through the chat. We have a free monthly legal consultations with attorneys that support our work. And if you need any support with any legal entity issues, please feel free to register. We have one this Thursday, but we also have one next month. And we'd love to support your small business if you need it. But yes, thank you so much. And thank you for providing the slides and letting us record. It's going to be such a valuable resource for our small business. Well,
absolutely.
have a great day, everyone. Bye-bye.
Bye.